Hi there and hello once again. John Scholes here along with Sivan Tumarkin, and this is the Disability Law Show. Thank you so much for joining us again on this edition of the show. 30 minutes of knowledge is about to be given to you. You want to tune into the entire show. Reaching out, by the way, anytime during this 30 minutes or otherwise to Sivan or a member of his team. Simple, 1-855-821-5900. The number, we'll put that on the screen throughout the show. And of course, the email, help@disabilityrights.ca. I will give you yet another avenue to use, mydisabilityquestions.com. That is a place you can go anonymously, ask your questions to Sivan or a member of his team. Searchable database, which is cool, so you can check to see if an answer very similar or exactly like yours has been asked in the past. If it has, read it. If not, leave it there and a member of the team will get to it. We'll get to a bunch of emails today, Sivan, but we always start the show with the week that was, something you've been working on over the last week or two. What's going on, pal?
Well, John, listen, it's been a very, very busy few weeks. Again, with COVID, with the lockdowns all across the country, insurance companies continue, unfortunately, to deny legitimate claims for long-term disability. And this is what we do here. We, day in and day out, help individuals across all three provinces where we practice, where our law firm practices, which is Ontario, British Columbia, and Alberta. And we help people who've been unjustly denied their long-term disability claims. Now, last week, I had the privilege of joining at a mediation with my partner, James Fireman, whom you know very well, and he's also a long-term disability lawyer. And I joined him in a mediation. It was a Zoom mediation with a large insurance company. And what was interesting about that mediation is that I'm not going to tell you all the facts that happened there. Suffice it to say that the insurance company had cut off this lady, our client's long-term disability benefits, on the basis of an assessment that was performed by a psychiatrist that was hired by the insurance company. Now, interestingly enough, this psychiatrist that was hired by the insurance company actually concluded that our client is disabled from working. Despite that, the insurance company went ahead and cut off this lady's long-term disability benefits, leaving her with no income. And so she came to us, and of course, James began helping her out. And so that culminated in a mediation, which is essentially a confidential process, which is why I'm not giving you too much information about this, not the name of this lady or the insurance company or any facts. But what happened there was that it was myself, James, the mediator, an adjuster from the insurance company, and the lawyer for the insurance company. And each lawyer was allowed to make an opening statement. This is not court, okay? This is just a confidential process to try and resolve this dispute, which is when most of these disputes actually get resolved. And so James proceeded to provide his opening statement, and I was awestruck, to say the least, by his skill. He did not even focus on why our client deserves long-term disability. His entire opening statement was focused about the insurance company's bad faith conduct and how if this case ever went to court, the insurance company would likely be hit with punitive damages. These are extra contractual damages. So again, for people who have never heard us, John, talk about this before, when we go after an insurance company for a long-term disability case, we ask or we're claiming for the benefits that the individual is owed under the policy of insurance, income replacement, right? Money that they're owed monthly. Yep. But in some cases, the conduct of the insurance company is so bad, it's so egregious, that in our view, that means that the individual should be getting above and beyond what they're entitled to under the policy. Also, they should be getting punitive damages, punishment against the insurance company. And I'll tell you, this was a very long mediation, but at the end of the day, this lady came out with a fairly nice settlement here from the insurance company. They understood that if we went all the way to court, they want to avoid that, because if we did that, a judge would hammer them for their bad faith conduct. And so I'm giving this out as an example of the kind of cases that we typically see. Not in every case we have punitive damages that we can prove, but I'll tell you this, John, when people come to us and they come in desperation and they say, look, I need this money, I can't work. My doctors say that I can't work. And we get in the picture and we take over the communications and we start going after the insurance company. I'm telling you, people are relieved. And when we get this kind of a settlement, when the individual can get this money in their pocket focus on their health, focus on getting better. There's nothing that makes us happier than that. And that's a success story. And there are many, many others. And this is what I want to tell people out there who are listening right now. If you or someone you know has been cut off long-term disability or been denied long-term disability unjustly, please, please, please don't walk away from the money that's owed to you. Contact us. Let us talk to you for free. We'll tell you if you have a case or not. And if you have a case, it's your choice if you want to pursue it. But don't let the insurance company walk away with money they owe you.
You know, it's interesting in this case, too, because usually when there's a denial coming up, it's based on your own medical information as a patient, as a client of yours. So they send you out to one of their professionals, one of their doctors to have you checked. And if they say, no, he shouldn't, you can cut off his benefits, then they usually do it. But their own doctor said this person shouldn't be working, but they disregarded it and said, no, we don't care. We're going to cut you off anyway. That's bizarre to me.
It is extremely bizarre. What makes it more bizarre, John, in this case, is that the insurance company, after getting that report from their own psychiatrist saying that she can't work, actually wrote her and said, on the basis of this letter, we're cutting you off. It makes zero sense. And again, when people contact us, it's because they know they can't work. Their doctors confirm that they can't work, that they still need treatments, and yet the insurance company just ignores that, just completely ignores that. And the reason they ignore it, John, I see this day in and day out, the reason they ignore it is because most people walk away from the money that's owed to them. Most people think you can't take on an insurance company. Nothing is further from the truth. I'm telling you this now, not as just someone who works for injured individuals, but somebody who used to work for insurance companies. These insurance companies are playing a game with you. They're denying your claim. They know that you owe this money, but they're hoping you're going to walk away because you know what? A ton of people, most people, I would say, walk away from that money. They simply assume that there's nothing they can do, and that is simply wrong.
You know, I think it's interesting before we move on that you mentioned the mediation. That thing, I think that's worth underlining because a lot of people assume that, okay, first step is to reach out to you, have a chat, become a client, bang, we're going to court right away. And that so rarely happens. I believe Terry Corcoran, who's our contact in the insurance industry, was there for 30 years. We use him all the time in the radio show. He says over 30 years he's gone to court maybe 5, 6, 7 times tops in 30 years. So that mediation's really good, right?
Listen, forget about what you see on TV, okay? Forget about those criminal shows, those American shows. This doesn't happen here, okay? Yeah. Have I gone to trial? Of course I've gone to trial. Has James gone to trial? Of course. But it's so infrequent. It's so rare to go to court. Listen, it's too expensive for insurance companies. Insurance companies are not in the business of fighting these kinds of claims to court. They don't like that. And they especially don't like going to court when they know they're going to lose. They're playing a game with you. Which is why when we get involved, we understand the lingo, the legal lingo. We know what their weaknesses are. We know where to press. We know where the pressure points are. We understand the game that they're playing. And that's why there is no game when we get involved. We simply press the pressure points. We take the pressure off of you. That's the most important thing because, John, when people come to us and they're injured and they're ill, they need to focus on their health. That's what they're saying. That's what their doctors are saying. That's our job, to get them to focus on getting better. We'll deal with the legal aspect. We'll push back. We'll attack the insurance company. And that's how we resolve these kinds of claims. And if I was lying to you, I wouldn't be in business. And my firm wouldn't be in business. And frankly, many other lawyers would not be in business. We're in business because these insurance companies are doing something they're not supposed to do. And we can force them. We can force, a correction in their behavior. We can force them to pay you what you're owed.
I want to take a moment and talk about another website, Sivan, that is pocketemploymentlawyer.ca, designed by your firm and by your colleague and partner, Lior, to put a finer point on it. But, it says Pocket Employment Lawyer is the website, but it has something to do and a relationship to what you do. Explain that for a moment.
Absolutely. Well, one of the unique things about our law firm is that our lawyers practice in 2 areas of law, in 2 areas only. We don't do family law or tax law or immigration. We do employment law for individuals who've been let go from their jobs, and we practice disability law. But oftentimes those 2 areas are intertwined. You have somebody who's disabled, who's having difficulty with their employer, and vice versa, somebody who's having difficulty with their employer because they're ill or they're injured, and so they're having issues also with their insurance company. So what we did is we understand that there's some people out there who don't want to call a lawyer. They don't want to call us. They don't want to email us for whatever reason. They want to go on Dr. Google and get the information that they need. The problem is that Dr. Google doesn't give you the right advice. In fact, it's often conflicting and it's often wrong. And so what Lior and I came up with is this idea of a pocket employment lawyer, this free website where you can go on it And whether you have an employment issue or a long-term disability issue, you input the information that's relevant to your case without giving your actual identifying information. It's all anonymous. And you'll get the answers to your questions. It's essentially like a semi-AI, artificial intelligence type tool, and we try to simplify it. And at the end, if you want to contact us after getting the information you need, the answers you need, the accurate answers that you're getting, by all means, you can press the button and then the website puts you in touch with us. If you don't want to do that, that's fine. Close the browser and we never know if you're there or not. But the point is, Pocket Employment Lawyer, if you want correct and accurate and fast answers for your employment law issues or your long-term disability issues, go to that website. You will get it guaranteed.
Let's slide in a quick email, Sivan, before we take a break. Again, help@disabilityrights.ca is where you go. First one comes from Val. Val says, last year I had a seizure while at work. None of the medications I've tried so far are working. Now the insurance company says they will be cutting off my long-term disability benefits because I can't work in retail earning minimum wage. I'm still getting dizzy spells and losing my balance, so I can't stand for long. Am I still entitled to disability benefits?
Yes, the answer is absolutely yes. And this is something we see all the time, John, where an insurance company will not outright deny the claim. They'll approve the claim initially, confirming that you're disabled from working. But at some point during the claims process, they'll say to you, we think you can go back to work. We think you're ready. And by the way, that may be in complete contravention of what your doctors are saying. But for whatever reason, they want to cut you off claim. Again, remember, they're in the business of making money, and they don't make money if they have to pay you out on these claims. And so they'll look for any reason to start cutting you off or to start pushing you and pressuring you to go back to work. Now, sometimes what happens is that, and this usually happens around the 2-year mark, where the definition or the test for getting long-term disability changes in the policy, in most policies. For the first 2 years to get LTD in most policies, you have to show with the help of your doctors that you cannot do the occupation, your own occupation. Okay, it's called the own occupation test. Beyond the 2-year mark, the test changes to any occupation for which you're suited by training, education, or experience. And so what happens often is that insurance companies will pay you up until about the 2-year mark, and then they'll take the position, for whatever reason, that they think that you can earn commensurate income or similar type income in some other profession. We see this all the time. And many times when they say that, it's completely nonsense. You know, the jobs they find for you are either not suitable for you because you don't have any education or experience in those jobs, in those occupations. And sometimes, you know, they will take the position that you can do X and Y job, but guess what? That job pays you 30% of the job that you held before you became disabled. And that's not appropriate. And so what I tell people is, if you are in a situation where you cannot work, you get to that 2-year mark, or at any point during the policy, you cannot work and your doctors confirm it, and you continue getting treatments, trying to get better, and the insurance company tells you we're going to cut you off, you call me immediately. You'll speak with me or someone on my team for absolutely free. And our job is to give you the advice you need. And if after speaking with us, you're going to make the decision that you don't want to do anything about it, that's fine. That's your decision. But at least you'll have the options. You'll be empowered. And John, that's the key here, right? I get those kinds of emails, voicemails. I speak with people all the time. They think they have no options when they're dealing with an insurance company that cuts them off or pressures them to go back to work. No, you have options. And the main option is to stand up for your rights. And that's what we're here to do, to educate you, to help you stand up for your rights against these bully insurance companies.
All right, let's take a short break. When we come back, dealing with a difficult employer while you're on LTD. That is on the way. This is the Disability Law Show. Stick around. We're coming right back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Thanks for sticking around. Sivan Tumarkin, of course, and John Scholes here. Want to get into the topic for the day, Sivan. We'll get through these, and that is dealing with a difficult employer while you're on LTD. Number one is this. Some employers think that it's okay to let an employee go while the employee is on long-term disability. Is that okay, and what can that employee do about it?
Well, no, absolutely that's not okay. And that's one of the things that I tell people is that, you have rights. And those rights extend to your employment, those rights extend to your insurance policy and your relationship, your contractual relationship with your insurance company. Right. And sometimes, listen, the insurance company is paying you what they're supposed to, but it's your employer who then comes around and says, well, we have to replace you. If you're not coming back, nothing we can do about that. We're going to have to let you go. And sometimes they just unilaterally start changing your job while you're off work, changing compensation. They can't do that. And John, people call me sometimes thinking that it's okay. They're just confirming because, somebody in their family heard me speak and they just want to confirm if it's okay for their employer to have let them go while they are on LTD. And the answer is no. But here's what you need to understand. There are ramifications to standing up for your rights when it comes to your employer, because whatever happens with your employer may affect your long-term disability claim. And that's why it's so important to go to a law firm and to lawyers who have a specialty, who have an understanding, an in-depth understanding of both areas of law, because they are intertwined. The employment law aspect of your case may affect your disability aspect of your case and vice versa. And if you don't understand, and if you go to a lawyer that doesn't understand the difference, guess what? You're going to be out of pocket at the end of the day. And your lawyer may not have even realized that there's going to be some kind of ramifications for resolving an employment claim. So my point is this. If you are dealing with an employer who thinks that it's okay to let you go while you're in disability, you should be contacting us immediately and speaking with one of our employment lawyers.
Well, you touched on it, and to mention the overlap between the two disciplines. So can an employer let someone go while they're off, or even change their salary for that matter? What happens there?
No, they can't. And if an employer does that, so first of all, if they let you go, that is a potential human rights violation. Okay, this is against the Human Rights Code. It's not allowed. You cannot let an employee go. You cannot fire an employee who is disabled. This is under human rights legislation across the country. That's number one. And we can do something about that to get you compensation. That's very, very important to understand. Number two, if the employer changes important aspects of your job, your salary, your position, things that are very significant to your role in the company, well, guess what? That in itself could constitute constructive dismissal. So again, you potentially could have recourse by way of compensation from the employer. But again, it's important to understand how that will impact your long-term disability claim, because there will be an impact. And again, every case is a bit different, which is why we tell people contact us so we can speak to you about your specific situation and minimize the amount of money that you are going to lose out at the end of the day if you don't take this into account.
So if you take this client who's been off for a while, they figure, okay, I'm getting a little better. Maybe I'm doing a return to work. Maybe I'll try to get back there. At that point, does the employer have to accommodate that employee if they need any accommodation? And at that point, does the insurer say, okay, we're good. Well, you're going back to work, so we're cutting you off?
So that's something that happens, unfortunately, quite a lot, where a person thinks to themselves, well, you know what, I'm going to try and go back to work. They're doing the right thing. They're trying to get back on their feet. But the doctor has said, you're going to need to be accommodated. And here are the accommodations that I recommend. And so you go to your employer, and the employer says, I can't accommodate you. And then you go back to the insurance company, and they say, well, this is now an accommodation issue. It's now an employment matter. It's no longer an issue for the insurance company because you were able to try and go back to work. And so a person then is stuck between a rock and a hard place. The employer is not letting them back in. The insurance company says, yeah, we don't have to deal with you. You're not disabled anymore for the purposes of the policy. What do you do? Again, this is why our firm is so unique. Because at that point, if you speak to somebody at our firm, it will likely be a lawyer that has a dual specialty, a dual expertise in long-term disability and employment. Because the way we look at it, somebody here is going to have to accommodate you. Either the insurance company, they're going to have to put you back on plan and pay you for being off work under the policy, or the employer is going to have to come back and say, no, we can't accommodate you. And remember, from an employment standpoint, employers have a duty under the law. And this is black and white. They have a duty to accommodate up until the point of undue hardship. And where is that point? That depends on a specific case. But what's important here to understand is that you should not be left out, in the cold. You should either be allowed to try and go back to work with the accommodations the doctor has said you need, or if you can't do that and the employer cannot accommodate, then you deserve to continue getting paid under the policy. So we can help you with that if you are somehow stuck, which is unfortunately, John, something that we see a lot now during COVID.
It's good stuff. We'll take a break, pal. When we return from our short break, what to do if your insurance adjuster is causing you even more stress. We'll tackle that on the Disability Law Show coming up.
People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Thank you for hanging around. Disability Law Show going to continue here. I mentioned at the beginning of the show, Sivan, another website, mydisabilityquestions.com. Want to get to a question from there. This time it's Jonah. Jonah says, my doctor says I'm still not able to work due to chronic back pain from arthritis in my spine. My insurance adjuster, however, has been constantly asking for updates, and their behavior is bordering on harassment. Is there any way I can ask for a new adjuster?
Yes, Jonah, you can absolutely ask for a new adjuster. As to whether or not you'll get a new adjuster is a different story. But look, I've been hearing this quite a lot, John. This experience that Jonah has here. Adjusters are not allowed to bully you. They're not allowed to harass you. Remember that the relationship between the insurance company and you is a very unique and special one. In fact, courts have recognized that there is a fiduciary obligation, a very special set of relationship terms that apply to this policy of insurance that you have with your insurance company. They're supposed to treat you in good faith. They're supposed to treat you, as an insured, and that doesn't necessarily just stop with disability policies. It applies also to house insurance policies, travel insurance policies. Whenever you're dealing with an insurance company adjuster and an insured person, you're looking for that respectful relationship. Now, what happens if you have an adjuster that is very bullying, that is just, the conduct is just completely egregious? You need to record everything. You need to confirm everything in writing to the adjuster. You may even not want to speak with the adjuster by phone. It may cause you too much stress. As far as I'm concerned, if that happens and the manager at the insurance company is refusing to change adjusters, inform the insurance company, the adjuster, that you're only communicating in writing. Inform your doctor of what's happening. Make sure that this makes its way into your conversations with your doctor, and explain how this is aggravating your condition. And the reason why all of this is important is because if at some point down the road you are cut off disability and we have to step in, we're going to look at all of these documents that you've created, the clinical notes and records from your doctors where they confirm this kind of behavior and what it's been doing to you. And we're going to use that. We're going to boomerang that against the insurance company with a claim for punitive damages and aggravated damages. So no, the answer is that insurance adjusters are not allowed to harass you, to bully you. Unfortunately, that does happen. Again, I'm not talking about an insurance adjuster that says hello instead of hi, John. I'm talking about situations where the adjuster is just being very mean, not listening to you, not listening to your doctors, just being very condescending, you need to stand up for your rights. And if it gets really, really bad, then reach out to me and let's have a conversation about your specific situation, and I will tell you what you need to do going forward.
Let's get a quick email in here, Sivan, with our remaining time. Bartek writing in says, I've been on LTD for 4 years due to PTSD, depression, and anxiety. My doctor said that if I was to return to work, it must not be the same office or department I left, as it will generate too much stress. My employer is refusing to accommodate these requests. Now the insurance is saying that I'm no longer disabled because my doctor has cleared me to return to work and will cut off my benefits. What are my options?
Well, the fact that you've been on disability for 4 years, if this is a regular insurance policy, that means that the insurance company has essentially confirmed or acknowledged that you are disabled from any occupation for which you are suited for by training, education, or experience. But remember that this assessment is an ongoing assessment, meaning that if your doctor says that you're clear to go back to work in a different office, different environment, that could potentially raise some issues for you with the insurance company. Remember that LTD, long-term disability insurance, it's not bad boss insurance. If in fact the issue stems from your workplace, and that's the reason why you can't work. It's not because you can't simply do your occupation. You're having difficulty doing the essential tasks of your own occupation or any occupation. If the issue is a toxic work environment or other such issues associated specifically with your workplace, you may then have an employment claim against your employer. And of course, we can help with that. But that said, John, in many cases, doctors, their goal is to get somebody back to the position they were before they became disabled. And so sometimes doctors will take an optimistic tone and they will recommend that this person, look, I think you might be able to try and go back to work, to some kind of work, but I don't recommend that you go back to your workplace. There's a nuance here. That doesn't mean that the doctor thinks necessarily that this person is able to do their job. It doesn't mean that the doctor says that the only issue here is the particular workplace that created the problem in the first place. It could very well mean that the doctor is saying, I think you might be ready to go back to some kind of work, but I certainly do not suggest that you go back to the initial location that created the problem in the first place. So again, but the issue is that in many cases like this, when doctors put pen to paper and they write these things, they don't write it with the view of how is the insurance company going to interpret my letters. And what happens is the insurance company ends up cherry picking information from these letters and end up then rejecting your claim or telling you your benefits will cut off when you are in fact not ready to go back to work. So again, if you're in that situation, there's so many variations, there's so many shades of gray. This is why I tell people, go to mydisabilityquestions.com, the website you mentioned, John. You know, you can write your questions. I answer these questions for free each and every day from across the country. People literally post questions from across Canada, and I answer all of them for free. Or you just give us a call or email us, and we'll talk to you about your specific situation. Sometimes it's just a matter of actually speaking with your doctor and explaining, here's what the insurance company is looking at. Just making sure the communication, there's no communication breakdown. And oftentimes we can rectify the situation, and the insurance company continues to pay the individual once we, make that right. But sometimes they don't. And sometimes we have to be heavy-handed with the insurance company to make sure that they pay our clients what they're owed.
Yeah, it's always worth a chat. It's no good just to sit idly by on your laurels and get worse and worse and worse and not end up going back to work at all, right? You want to take care of it, nip it in the bud.
You want to make sure you do that. I think one of the things that I've seen, especially over the last year and a half with COVID, is people sitting on their laurels and just sitting back and thinking things are going to be okay. No. If the insurance company is giving you problems, trust me, those problems are not going away. Not until you get the advice you need and understand how to stand up for your rights.
Reach out, as Sivan says, anytime, mydisabilityquestions.com. You can go there. The email is help@disabilityrights.ca. And a reminder, simply disabilityrights.ca, the website is a good place to find a route to our radio show as well. So you can do that, and we'll catch you next time right here on the Disability Law Show. Thanks for watching.
Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed.